Good morning and welcome back. For those of you who don't know me, I'm Pat Miller. I've been with Sherman and Howard since 2000, and for the better part of the last 15 years or so have dedicated almost all of my practice to occupational safety and health issues. So what Alyssa Levy, who you can see on your screen as well, she joined Sherman and Howard in 2016, and a large part of her practice is helping out with OSHA matters that we handle. So I just want to reiterate what everyone else has said this morning, that it's a pity that we're still having to do these events virtually. There's just no substitute for seeing everybody live and shaking hands and chatting, but hopefully next year. So we're going to spend the better part of the next hour doing our general OSHA update, but obviously given the pandemic, it's going to be very COVID-centric. We're going to cover what the Biden administration is planning on doing OSHA-wise regarding the pandemic, but we're also going to cover a lot of other areas where states and even private parties have attempted to deal with COVID. If it seems like we're jumping around a lot, it's because we are. And if it seems like we're not providing clear answers to a lot of issues, it's because we're not. Because given how rapidly things are advancing, especially with respect to the vaccine, it's just really hard to prognosticate where we're going to be in the next few months with COVID and OSHA. But I'll go ahead and get started, and next slide, please. I wanted to start with, it's a state statute. It doesn't directly address OSHA matters for preemption reasons, which Alyssa will talk about in a little bit. But I just want to reiterate that even though we're coming somewhat out of the pandemic, and even though things are opening up a little bit more, we still have a pretty robust whistleblower law on the books here in Colorado. This is a statute that was passed a few months after the pandemic hit, and it really is a lot more robust than some of the traditional retaliation statutes that we normally work with, especially Section 11C of the Federal Occupational Safety and Health Act. Basically what it does is it prohibits a principle. Notice that it's not limited to employers, so it can be general contractors or anyone else on a work site. Anyone basically from discriminating, retaliating, or taking adverse action against workers who basically raise concerns about a principal or an employer not taking the proper COVID precautions or precautions in any public health emergency. So that basically covers you can't terminate somebody for saying, hey, you're not requiring masks in the right places, that sort of thing. So it's important to note that because the statute is still on the books, and with the opening up that's taking place, employers are making a lot of different decisions, all of which are valid given the current state of things. So what we're going to be seeing, I think, is workers maybe saying employers aren't going far enough and complaining about it. And if they do refuse to come into work, for example, we'll talk about work refusals later, how is that going to be handled under this state whistleblower statute? We haven't seen a lot of activity under it yet, but we expect to in the future, again, with employees who are not thinking that their employers are taking things far enough. Next slide, please. May I have the next slide, please? There we go. Thank you. So along with the prohibitions in the statute against retaliation, there are a lot of implementing rules. I certainly am not going to go through each of them. This covers more than just the retaliation statute. It also covers the wage hour statute and various other statutes that were promulgated by the General Assembly in response to COVID. But it basically, next slide, please. One of the things you need to watch out for is there are noticing and posting responsibilities still. So I know you all have your posters up, but we have to make sure those are up and that we give employees notice under the statute as well. Next slide. Yeah, and there is the requirements for the HFWA notices, as well as the particular requirement to notify employees. Has to be in their language, that sort of thing. Again, I haven't seen any complaints raised on these posting issues, but just wanted to reiterate it to let you know that it's out there. So, and the reason I brought this one up at the beginning is because this isn't the main area that we're seeing our questions come in related to COVID. Retaliation is never a good idea, but just know that this statute is out there, and it does provide for some pretty robust remedies. It allows for private causes of action, investigation by the state, the whole 9 yards. So again, the concern is, what are employees going to do when they think you're not going far enough, even though what you're doing is permissible under current CDC guidelines, as well as current state guidelines. So we'll talk a little bit about that later on in the session in our Q&A. And I should have mentioned, by the way, if you have any questions during our presentation, feel free to put them in the chat box or via the Q&A link that we have as well. We'll be checking both of them, and we'll leave 10 or 15 or so minutes at the end. We have some frequently asked questions that we're going to be covering, so that might answer a lot of the questions that you have. But again, feel free to submit any questions that you have. Next slide, please. So I'm going to turn it over to Alyssa for a minute. She's going to talk about other mechanisms that parties have sought to get relief for various COVID-related issues, and how those cases have turned out, and basically how everything has been put back into OSHA's lap in terms of enforcement. And then I'll take over from there and talk about what OSHA is doing. But we wanted to again highlight the different mechanisms that people have taken when they're not satisfied with what OSHA is or is not doing. So, Alyssa, I'll turn it over to you.
All right. Hi, everyone. I'm Alyssa Levy, and like Pat said, we work together in our OSHA group within Sherman and Howard's employment practice. Thank you all for attending today. So I wanted to talk about OSHA matters in civil courtrooms. During the COVID-19 pandemic, we have seen a smattering of cases across the country to enforce safety and health measures through civil matters, where plaintiffs were not satisfied with the level of enforcement or involvement of OSHA in their workplace. So we chose a few examples of civil cases filed during COVID to kind of paint a picture of how this litigation has proceeded. Now, about a year ago, we saw workers starting to request COVID-related safety injunctions all across the country. Workers wanted the courts to mandate safety protections and precautions where PPE would not otherwise be required for a job if not for COVID-19. Workers wanted mandates for measures like masks, gloves, social distancing, hand washing, cleaning requirements, and temperature checks. For the most part, their demands were not outrageous. They were pretty reasonable, but these workers thought their employers just weren't protecting them, so they wanted to require certain safety measures at work. So for example, in Chicago, McDonald's workers argued that inadequate COVID-19 safeguards constituted a public nuisance that would further spread COVID. The court there in Illinois just said that employers must comply with state orders, which already required straightforward COVID protections like social distancing and mask wearing. In June of 2020, a California court also enforced an injunction against McDonald's, ordering compliance with state and federal COVID-19 orders. They also enforced specific requirements for the restaurants, though, such as for them to be sanitized, provide masks and gloves to employees, hand washing breaks, and temperature checks. So for the most part, these injunctions basically just said the employer had to comply with the state's laws. Around the same time as these decisions, in about May 2020, however, a Missouri court ruled against an injunction in which Smithfield Foods workers sought enforcement of basic safety measures in their workplace. The court pointed to the primary jurisdiction doctrine, stating that OSHA and the USDA had the expertise to grant such safety measures, but the court did not. The problem at that time was that the president had delegated authority to the Secretary of Agriculture over compliance with OSHA and CDC guidance. But then the court said that OSHA actually has the expertise and primary jurisdiction. So employees and employers were stuck in this sort of limbo with nowhere to turn for enforcement of COVID safety measures. So the primary jurisdiction doctrine allows the court to refer a matter to the appropriate administrative agency for an initial ruling. So this Missouri court declined to enforce employee safety measures because of OSHA's primary jurisdiction. Now, a few months after all this, in November of 2020, a court in New York dismissed the case brought by Amazon workers for the same reason, that primary jurisdiction belonged to OSHA. The reasoning in this case also included that there was a substantial danger of inconsistent rulings on safety and health measures if the courts made separate decisions all over the country, which is really why a central health and safety agency exists in the first place. Now, more recently, in March of 2021, a Pennsylvania court dismissed the case that was filed back in summer of 2020, in which a group of employees sought a court order to compel OSHA to take steps to abate imminent dangers to employees related to the transmission of COVID-19. Employees had raised safety concerns back since March of 2020, and even requested an immediate OSHA inspection through an imminent danger complaint. Eventually, OSHA concluded its investigation, and they found that there was no imminent danger. The court said it only had jurisdiction to compel action against the employer if the Secretary of Labor arbitrarily and capriciously rejects the finding of imminent danger. But because there was no finding of imminent danger in the first place, the court's hands in this matter were again tied due to a lack of jurisdiction. This Pennsylvania court made an interesting observation that future recourse for plaintiffs in these types of cases, those seeking safety and health protections, likely lies in changed legislation, not just through the courts. With the number of civil cases that rejected injunctions when OSHA declined to require certain safety measures, we may see attempts to change the law even during this current administration. A slew of other cases have been filed all over the country alleging claims such as public nuisance and seeking injunctions to implement safety measures. Many are class actions, some are advocacy groups, others are by individuals. Civil courts are equipped to issue injunctions, but really have just enforced local law and basically deferred to OSHA. So even though plaintiffs have been creative in suing on technicalities, most of these civil cases end up meeting the same fate of dismissal, really under the primary jurisdiction doctrine. So overall, there have not been any great successes yet by plaintiffs in these cases. Under the current administration, if OSHA inspectors have a different eye for what they would consider imminent danger in the workplace, we may see OSHA enforcement on the rise and a decrease in these civil claims. But plaintiffs have 2 years to bring these civil cases, so really only time will tell. And there's also a 6-month statute of limitation for OSHA matters, so there's still some potential exposure there as well. Really, primary jurisdiction is the bottom line here, though, and that OSHA enforcement regarding COVID-19 is really not as robust as we thought it would have been. Next slide, please. So in addition to those ad hoc civil suits against employers, we've also seen unions pursuing employee protections for COVID-19 measures directly against OSHA. What seems like way back, it was March of 2020, OSHA came out with the decision that an emergency temporary standard at that time was not necessary for COVID-19 matters. The AFL-CIO which is the largest federation of unions in the U.S., they appealed OSHA's decision not to issue an ETS. In June of 2020, the U.S. Court of Appeals for the D.C. Circuit upheld OSHA's decision that at that time an ETS was not necessary. A little while later, the unions tried again for emergency standards in October of 2020. There were 4 unions, and they represented education, healthcare, and municipal workers, and they demanded that OSHA adopt an infectious disease standard. However, when Biden issued his January 21st, 2021 executive order, this union pursuit was put on hold. And we'll talk more about the executive order in just a minute. But the significance here is that unions were expecting the ETS to be rolled out in March of 2021. But as many of you are probably aware, we still have not seen a federal emergency standard. So the union's pursuit may be one to watch if they continue to put the pressure on OSHA. So unions historically pursue worker protections. The bar to get OSHA to promulgate a standard is pretty high, though. So this one may be one to watch, but it may just be another chapter in the story of unions making their claim to get safety protection. Next slide, please.
Thanks, Alyssa. So I'm going to talk a little bit about the executive order that Alyssa referenced. It was one of the first things that President Biden did after his inauguration. It was in connection with many other steps he took, but it required OSHA not to actually enact an emergency temporary standard, but to look into the issue and come up with a decision by, I believe it was March 15th. Of course, March 15th came and went, and there was nothing on it. And I'll talk about a little bit more about what an emergency temporary standard is, but it's not unique to Fed OSHA. As most of you know, states are allowed to run their own occupational safety and health programs. Many states, almost half of them do. Arizona runs its own program. Colorado does not. It's a federal state, so it goes along with whatever Fed OSHA does. But this shows that Fed OSHA was really late to the game because at the time of the executive order, 14 states had already enacted emergency COVID measures. They kind of ran the gamut. California, as you can imagine, was very, very protective, had very rigorous requirements. Other states like Virginia was a little less onerous in terms of what it would require, but there was a lot of activity out there, and state OSHA programs were enforcing these, and we're taking a hard look at them. I've had conversations with attorneys in Michigan, for example, that say because of the governor's interest in this issue there, that most of their clients have already been inspected with respect to COVID-related matters, and that's just enforcement activity we don't see here in Colorado because of the lack of a standard that applies. Same in Arizona. The Arizona legislature hasn't acted on this either. So what you're left with, short of a standard, is enforcement under what's known as the general duty clause, which applies in the absence of any particular standard. I'm sure you've seen from the news that there have been some high-profile cases, including here in Colorado, where citations under that have been issued for COVID. But for the most part, they've been very, very few and far between. Next slide, please. And here's a couple of those examples as to how different states have been treating things. You look at Virginia, for example, and it basically just says you have to classify various job tasks for COVID risks, develop policies for reporting symptoms and reporting cases. California, on the other hand, has some provisions for actually paying employees who were gone due to COVID concerns. Now, those kind of wage hour issues, as was discussed by Carissa this morning, aren't unusual. But what is unusual about California's is you don't tend to see those kind of pay requirements in the context of occupational safety and health. So as usual, California is leading the way, if that's the way you want to put it, depending on what you think leadership is. But they're really out in front of requirements related to COVID. Next slide, please. So other requirements from different states, most of them have masking, training, mandated distancing, reporting cases to health departments, and enforcing hygiene. And we're going to talk a little bit later about what the change in CDC guidance, how it affects these things, and how the efficacy of vaccines does the same. But in all of these states, with these requirements on the books, they're going to have to go through some amendment now that the vaccines are taking hold. And that's one problem the feds don't have because they haven't enacted a standard yet. But next slide, please. So basically, and so I brought up those state examples because they provided a kind of good guidance of what we thought we might expect from Fed OSHA under an ETS. I brought up California in particular because the nominee to head OSHA, Doug Parker, who has been nominated but hasn't been voted upon yet, and his vote isn't even scheduled yet. He's the chief of Cal OSHA. He runs that department. So we would expect that if OSHA ever came out with an emergency temporary standard, it would look somewhat more like the California style than the Virginia style. But so what is required for an emergency temporary standard? Employees have to be exposed to a grave danger that of a new hazard that's been introduced into the workplace. Now, because OSHA has sat on this for well over a year, and because the rates of COVID infection are going down, because of the efficacy of vaccines and the increased number of people who are getting them, any standard that comes out may actually be challenged on this ground alone, that employees, because of the availability of vaccines, are no longer exposed to a grave danger. Therefore, you, OSHA, cannot promulgate an emergency standard. You have to go through the normal notice and comment rulemaking, which sometimes can take years because you haven't met your burden to show that element. So I think the longer this goes on without OSHA doing anything about it, the harder that prong is going to be. Next slide, please. So another couple of requirements for emergency standard to be upheld is that the standard is necessary to protect employees from that danger. Now, again, that might be a hard thing to show depending on what's in the standard because, again, the availability of vaccines makes it so a standard that OSHA can come up with, for example, if there's a mask mandate in there or if there's certain hygiene protocols that are in there, employer groups who are going to challenge any such standard could say those steps are no longer necessary. So here's kind of the practical issue with OSHA's emergency standard. They have written one. They haven't released it to the public yet. They sent it to other federal agencies for internal review. And the reason I think we haven't seen that standard come out yet is because of what the CDC did a couple weeks ago, basically surprising everybody when they came out and said, if you are vaccinated, you no longer need to wear a mask, even indoors. So I would bet you a steak dinner that OSHA's emergency temporary standard had a mask requirement in it. And CDC didn't pick up the phone and call OSHA and say, hey, here's what we're going to do. Masks in the workplace for those who are vaccinated are out the window. So the standard didn't get released, whatever it said. OSHA did come out and say, we kind of me too what the CDC says, and we're not going to be enforcing mask mandates in certain situations. Anecdotally, I've talked to people at OSHA. They're kind of frustrated with this process as you all are, because we don't know what OSHA is doing. There seems to be conflicting messages coming from different federal agencies. And they're frankly not, and again, don't quote me on this if they show up at your door, but anecdotally, again, I'm being told that they just don't want to go out on a limb and at this point enforce mask mandates because under the general duty clause, it's going to be really hard to win some of those cases. I think what you might see is enforcement on large-scale infections that have taken place in the past before the efficacy of the vaccines really was brought to bear. As Alyssa said, OSHA has 6 months to do their investigation. So for outbreaks that happened during the winter and that OSHA has been looking at, they may still be able to enforce some of that stuff at that time. But frankly, I don't see OSHA actually releasing the emergency standard. I don't see them increasing enforcement under the general duty clause going forward because the risks are just not there. So it's one of those examples of, despite the agency's good intentions and best efforts, you can't sit on a pandemic for a year and 3 months and then expect to make a real difference at the end. You know, the time to do all this stuff was when the pandemic happened. And as Alyssa said, OSHA under the prior administration made the decision that an ETS wasn't necessary, and it's getting less and less necessary every day. So I don't expect that we're going to see much, if anything, ultimately on that. Next slide, please. Okay, and here's the process that I was talking about that is really going to make it hard for OSHA to win one of these challenges. And the way it works is when an emergency standard is promulgated, it is immediately effective. So employers to get an injunction against the enforcement of that standard have to make a substantial showing that they'll prevail, and that without the stay, they'll be irreparably harmed. Now, I don't know that the employer might be able to show those ultimately. It's hard to say that a mask mandate, for example, is going to ruin your business. But it's possible that a court could look at this and say an employer is able to make a substantial showing that it's going to prevail, again, because the standard is no longer necessary and the grave danger doesn't exist. So all the more reason why this executive order, in my view, probably isn't going to come out is because OSHA's attorneys know that it's going to be challenged. And again, with every day that passes and the standard is less and less necessary, the more likely it becomes that a challenge will succeed. Next slide, please. So the other things that are in the executive order outside of the emergency temporary standard, OSHA has done. They've updated their pandemic guidance. They've issued a national emphasis program that Alyssa will talk about here in a few minutes. And that's in the third bullet point there. The fourth bullet point is kind of interesting. This executive order says, well, you, Fed OSHA, have to look at these state plan states and make sure that they're requiring what they should be requiring. Well, as I mentioned, 14 of the state plan states were well ahead of Fed OSHA and are doing more than Fed OSHA, so they really don't need that oversight. But this goes to show that, you know, shortly after President Biden was inaugurated, there was a lot of, hey, let's get on this, let's move. And here we are early June and nothing has moved. So I think the science is taking care of it. I think states and local governments are taking care of it. But the feds have just been a little bit slow here. Next slide, please. So again, the CDC guidance, in my view, is why it's being derailed. You know, again, it's hard to enforce a mask mandate when the head public health organization in the country says it's not needed if you're vaccinated. Next slide. Okay, I'm going to turn it back over to Alyssa. She's going to talk about the NEP, which is still in effect despite the lack of a standard. So this is one that we will still need to be paying attention to.
Thanks, Pat. So you heard Pat discuss all the reasons and excuses and everything going into why OSHA has not put out their emergency temporary standard yet. But around the time we actually expected the emergency temporary standard to roll out, we instead got from OSHA a COVID-19 National Emphasis Program, or NEP. NEPs are tools that are utilized by OSHA on a temporary basis to address certain hazards in high-risk industries. And this is not the same as, and it doesn't take the place of an emergency temporary standard, though. The National Emphasis Program went into effect on March 12th of this year and is set to last for 12 months. OSHA's goals with the NEP are to reduce and eliminate workplace exposures and to look into industries that have a high frequency of close contact exposures. OSHA says that they anticipate inspections related to COVID-19 will comprise at least 5% of all inspections and will focus on certain critical industries, and they say that is until further notice. So employers in covered industries should be prepared for a programmed inspection while this NEP is in effect, but employers in other industries are not off the hook here. Unprogrammed COVID-19 inspections may still take place at any worksite where there's high rates of exposure. So OSHA came out with 2 master lists which identify their areas of focus for this NEP. And the first is establishments with high rates or frequent exposure. And the second is establishments with high illness rates. And this is based on OSHA 300 data. Not surprisingly, most of these establishments of focus for OSHA are in healthcare. Other areas of focus include meat processing, grocery stores, warehousing, and restaurants. There's also industries included, such as agriculture, construction, food and beverage manufacturing, and machinery manufacturing, among others. OSHA area offices may also add other establishments to their list, and this would be based on local information that they have, such as information they receive from like local health departments. OSHA is prioritizing COVID-19 related inspections that involve deaths or multiple hospitalizations due to occupational COVID-19 exposures. And OSHA has also said that they're adding the focus of protecting workers from retaliation. And Pat talked about that a little bit in the beginning. So basically, enforcement-wise, OSHA may not find a lot to cite with COVID safety protections, but they may for employees who are making those complaints, because you don't have to prove a workplace is unsafe in order to claim retaliation. Next slide, please. I'm going to hand it back to Pat.
Yeah, and I want to pick up on that point that Alyssa just mentioned. It's really important to know that you might remember a few years back, OSHA actually came up with its own retaliation standard as opposed to going through the normal litigation process. So they actually have the authority to come in and issue you a citation like you would normally see for safety and health issues for taking steps against employees who report injuries or illnesses. So if an employee, for example, comes up and says, hey, I think we've got a COVID issue here, and I think there's a lot of workplace exposures, and I can identify who they are, and the employer says, well, we don't like that, there's nothing to see here, you're gone. That's the kind of thing that can go to OSHA and can get you inspected for retaliation, even if the employee's wrong. As long as the complaint is made in good faith, you can end up with those issues, similar to the state statute. So even though COVID's kind of going away in the workplace, it's not going away in terms of employee perception and complaints. So keep that in mind. And that goes along with this first bullet point here as to what to expect under the Biden administration with OSHA. Increased enforcement of anti-retaliation, not just with respect to COVID, but with respect to all the statutes that OSHA investigates claims of retaliation under. I believe there's 23 federal statutes now that they have there. A few of them are listed. STA, FEMSA, Air 21. So the retaliation issues is not going away. And that third bullet point there is the anti-retaliation regulation I mentioned. So Alyssa's point is well taken. Keep looking out for those retaliation issues. Next slide, please. I wanted to dedicate an entire slide just to this notion because I wanted to sink in. President Biden early on, and even on the campaign trail, said that it's his goal to double the number of compliance officers and inspections that take place. A lot of that's going to depend on how the budget turns out, but I will say that OSHA, for a federal agency, has one of the smaller budgets around, so it wouldn't take a lot, especially given some of the spending proposals that are out there already, to see that their budget may get doubled. So obviously, double the number of compliance officers, double the number of inspections, double the number of citations. So, and we see this all the time when administrations shift between political parties, enforcement varies accordingly. And so we are going to be seeing that. Next slide, please. Another thing we're going to see is more of what they call significant enforcement cases. Those are cases that involve over $100,000 worth of penalties. We're going to see a return to press releases, the name and shame game, as we like to call it. Under the Trump administration, those were gotten rid of. And cases on their website when a citation is issued before an employer ever has a chance to clear its name or to negotiate the settlement down or even to win the case. So they don't issue press releases when we win, but they're going to be going back to that practice post-citation. So an emphasis on record keeping, we're going to see that. I'm going to talk about record keeping with respect to COVID here in a minute when we get to our frequently asked questions. And finally, they're going to keep plugging away on the general duty clause, I think. But as I've said a few times here, with each passing day, the recognized hazard in the workplace, which is one of the elements of the general duty clause violation, is less and less as we're opening up and we're getting safer in the return. Next slide, please. So we've timed this out pretty well, Alyssa. We said 40 minutes in, we'd get to our FAQs. And I do see we have some Q&As coming in. I think our FAQs here will handle some of those. But these are the big four. These are the questions related to COVID that we get more than any other. So Alyssa, you want to take it away on the first one there on masks?
Sure. So like Pat said, we came up with a few questions that will hopefully dispel some of the chat questions we're getting. And these are questions we've been asked fairly frequently and that many employers are still wondering about. So we thought we would cover them for everyone. The first question is, are masks still necessary in the workplace? So OSHA recommends employers follow CDC guidance, which as of a few weeks ago says that vaccinated individuals generally do not need to wear a mask or physically distance in most settings, except where required by a federal, state, or local law or regulation. And in Colorado, the state is following CDC guidance. There are some counties that still require masks, though. So even though the CDC and the state may give the all clear to just take off your mask, make sure that you check local jurisdictions for their rules wherever you're operating or you have your employees. As an employer, you can require mask wearing for everyone, or you can require it just for unvaccinated employees. It's really up to you and what works best for your company. OSHA is not specifically getting into mask requirements based on employee vaccinations separately from CDC guidance. They're just going by the CDC guidelines. Someone in the Denver area office mentioned that OSHA is not enforcing masks under the general duty clause in light of these CDC guidelines. So if a workplace, if you're not requiring masks in your workplace, as far as we know, OSHA is not issuing citations on that basis. So our recommendation for this is to follow CDC guidelines for now, and that complying with CDC and state guidance is basically complying with OSHA. Do you want to do the second question on there?
Sure. So, and we've seen this a lot already, and we're going to see more of it as we continue to open up. We still have a lot of people who, justifiably or not, and in many cases it is, are still fearful of return to work, given the fact that COVID is still out there. So what's confronting employers is, we're getting these arguments that working from home is working just fine. They don't need to come into the office. What happens if you have an employee who simply says, I am not coming in. I'll work here, but I am not coming in. Well, that's akin to a work refusal. And that's kind of a well-established doctrine under OSHA retaliation law that has a very high level of scrutiny on it. So the typical case on work refusals used to be, hey, that girder is about to collapse. I'm not getting under it. And the employer says, well, then you're fired. Well, that's a work refusal that's going to be upheld because there's an imminent danger to the employee. But short of something like that, work refusals typically aren't upheld. Having an in-person requirement is a valid requirement. Employers can certainly say, despite the fact that we've been able to work from home for the last year, we now want people in there. So if a person refuses to do that, that is a work refusal. And under Fed OSHA retaliation law, and the state statute doesn't speak to this, but I think it will be evaluated similarly, that person's not going to succeed. You have to show that there is an imminent danger of death or serious bodily injury. With all the vaccines that are available and all of that, I have a hard time seeing how any employee is going to be able to make that case. So we may see work refusals come up, but employers can be fairly comfortable that the standard is going to be high enough that if you terminate somebody for flat out refusing to work, you're going to be on solid ground. Now, obviously, you want to make sure that you're still making the accommodations that are appropriate. You know, if you come in and you're still really nervous about COVID, if we can, we'll give you more space. Our non-vaccinated people will wear masks, that sort of thing. So work refusals, they could come up, but they don't. That's not the kind of thing that keeps me up at night. Vaccines, Alyssa, this is the big one. This is what we're getting a lot of questions on. So take it away.
Yeah, so this question we have seen a lot of, so hopefully this will be helpful to many of you. The question is, can our company require employees to get vaccinated? In some states, such as Colorado, an employer may have a mandatory vaccination policy, and you can even require proof of vaccination. That is not the case in every state, though. And be on the lookout of where you're operating and where your employees are, because some states have created laws or rules against this. For example, some states have prohibited the use of vaccine passports. So that kind of goes along the lines of what you can require in terms of proof of vaccination if you're requiring a vaccine. Alternatively, if you are not requiring masks or vaccines, you can run into local enforcement issues there. So just be aware of where you are operating, but in Colorado, you can require employees to get vaccinated here if you so desire, if that's good for your workforce and your company. So you can discern between vaccinated and unvaccinated individuals that are coming into your workplace or to your work site. It's up to you really as the employer if you want to require vaccines. And keep in mind also that this is, of course, subject to exceptions if you're requiring this, exceptions such as for medical or religious accommodations. Employees basically have to abide by your rules. There's companies that we work with that they are requiring employees to be vaccinated, and they are even requiring proof of vaccination by a certain date for employees to return to work. If they've been remote or even if they're at the work site, they set a date certain for that. Even if you are mandating vaccines, you are not required to set up vaccination appointments for your employees. You can assist employees in finding vaccines or setting up a vaccination day or something, but it's okay to leave it up to the individual to schedule and go get their own COVID-19 vaccine. You don't have to do that for them, even if you are mandating it. As far as OSHA is concerned on all this, there's not much enforcement unless there's really an egregious case. OSHA's really not getting into whether employees are vaccinated other than what the CDC is recommending. So what you see in the CDC guidance, that it's a good takeaway if you're looking for OSHA guidance right now. Pat, is there anything you want to add to that? Otherwise,
that really,
next question.
Yeah, that really covers it. The one thing that I could see happening in a really bizarre situation, but I've seen it worse before. Think about the example if employers who, for whatever political reasons, would prefer that you're not vaccinated. in the workplace? And can employers say, we don't want the vaccinated people? There's been some really far out thinking that vaccines might increase the risk of COVID in your system and you can shed it, all this stuff that isn't supported scientifically. But I could foresee a situation where an employer says, we don't want vaccinated people here. Lo and behold, there's a breakout. OSHA may come in that situation and say, well, that's a violation of the general duty clause because people should be able to get vaccinated if they want. So it's an extreme example, but like I said, we've seen things like that before. So record keeping, and I know we have a couple of questions, or a question from Melissa that I think that you've answered, Alyssa, and that I'll answer the second part of. The second part of her question is, so if you mandate vaccines, what happens if the employee, are you liable for something that goes wrong with the vaccine? You're not liable in terms of outside of the workers' comp system, I should say, in terms of any litigation or tort liability. But what OSHA would expect from you is that if you mandate vaccines and somebody misses work because of an adverse reaction, which we are seeing in the second doses of the Pfizer and Moderna, and even after the J&J. So if you mandate vaccines and someone calls in and says, hey, I'm not going to be able to come to work for a couple of days, that's an OSHA recordable event because you mandated it. Even if you didn't provide the shot, you mandated it. So if it otherwise meets reporting criteria, which is days away from work, transfer of job duties, anything like that, you do have to record it on your OSHA 300 log. I wanted to make a quick point on record keeping in general. Even with the opening up and COVID becoming less and less of a risk factor in the workplace, one thing we are seeing with OSHA inspections is record keeping. Are employers recording their workplace exposures to COVID? OSHA did come out with some guidance on this early on and basically said, the standard is it more likely than not that a person came down with COVID in your workplace? And I've advised dozens of clients with questions like that, and there was only one circumstance where I said, yeah, you need to record that. And that was a situation where two employees had it in a remote location where where the second person couldn't have gotten it from anyone other than the first person. So I said, yeah, that's recordable. But for the most part, how can you establish that it's more likely than not that the infection happened at work versus out in public? So, but just keep that in mind. If your workplace has kind of a cluster of multiple employees who work closely together, that's one thing you may need to look at. Going forward, OSHA is going to still be looking at that, even as part of your routine OSHA inspections that you get. So let me go to the Q&A here. We've got some good ones. Oops, let me see that here. Okay. So Lori's question is a good one. And I'll just read it here. Voluntarily adopting infection prevention practices for COVID-19 and other viruses in healthcare settings may still be a quality safety step to apply if they anticipate exposure to COVID or other viral patients, residents in their care or ambulatory clinics. That's absolutely right. So what OSHA is basically saying is we're following CDC guidelines, which in most cases, in most general industry or construction workplaces, don't require those kind of measures, whether it's masks or infection prevention programs. If you're in a higher risk setting, however, healthcare being the perfect one, I could foresee OSHA coming in and under the general duty clause saying, yeah, that's great for Walmart, but you run a healthcare facility where infections are rampant and you need to be doing more to protect your folks in terms of mask mandates and so forth. They still will look to CDC guidance, but I think even CDC guidance makes those carve-outs for any industries where there's more potential for exposure. Question, the likelihood of the workplace violence prevention bill passing for healthcare social services. I believe that question will be answered in Bill Wright's next session on workplace violence. I I confess I haven't followed that one too closely. So hopefully you attend that next session. I'm familiar with the legislation, but it's basically similar to the Violence Against Women's Act that was passed back in the 90s. This is a bill that deals with certain issues related to workplace violence. Workplace violence being something that there's no OSHA standard on, and it much like COVID, has been addressed through the general duty clause over the years. So I'm going to have to punt that one to our presentation in the next hour. I don't see any
There's one more question in there. It says, if someone receives the vaccine to return to work and they have a reaction, would the employer be liable? And we've sort of covered this in a roundabout way with some of the other information and in terms of reporting and recording, but the answer to that also is kind of a very lawyerly one of it depends. It's going to depend on certain factors because this could actually become a workers' comp issue in terms of employer liability. It's like Pat mentioned, some of the scenarios where if it's pretty obvious that this employee got COVID from the workplace, from other employees there that they're working closely with, then the employer may have some potential liability there. But it's probably going to come down to a workers' comp analysis of where else could they have gotten this from? Is it likely they got it here? What other kinds of exposures are there in this person's life? But just be careful of what you're asking employees in terms of privacy, because there's limits on what you can ask them for. Where did you get this from? What other health issues do you have? Things like that. But liability is not completely limited. It's an analysis and kind of an individual decision for each employee. And we have dealt with that in a few situations. So if you have questions and if that does come up for you, feel free to reach out and we can talk through it with you. Because there's a lot of considerations, including paid time off and things like that go along with COVID that you need to be aware of. So feel free to reach out if that does come up for you, because we are still seeing that even though more people are starting to get vaccinated.
Yeah. And I'll just make one more, Alyssa's answer there reminded me of one more issue that hopefully never comes up, but you need to be aware of, and that is separate from recording COVID-related issues on your 300 logs. There's also the issue of when are you obligated to pick up the phone and call OSHA and tell them about something COVID-related, and this has come up a lot. So say you have a case where if you're not sure and you can't meet that standard, more likely than not that the workplace caused the exposure, well, then you don't need to call OSHA if your employee is hospitalized or is killed because of it. But in those cases where you are reasonably certain that it is more likely than not that it happened in the workplace, you have to pick up the phone if your employee is hospitalized, but only if that hospitalization took place within 24 hours of the workplace infection, which in most cases, you're never going to be able to determine that. Even if a person got exposed on the last day they were in the office, most hospitalizations don't occur for a couple days after that. So we haven't had to advise clients to pick up the phone and call OSHA in many cases. Fatalities, if it happens within 30 days of the workplace exposure, and again, it's work-related, you have to pick up the phone and call there. If on the vaccines, if somebody has a reaction that puts them in the hospital within 24 hours of the vaccination, that you have to pick up the phone and call OSHA about that one too. So again, just keep those in mind. If you have any particular questions, obviously feel free to call Alyssa or myself and we'd be happy to chat. So with that, we're right at the top of the hour. Again, I can't stress how much we look forward to seeing everybody in person next year. But until then, I hope everyone stays safe and healthy, and we'll see you soon. Thank you.
And if you have other questions, feel free to reach out to us because we see there's some others coming in. So feel free to email or give us a call after this presentation. Thank you, everyone.